Welcome to this explainer. Let's jump right in and open today's court session on a genuinely fascinating area of commercial law, title transfer. Have you ever wondered what actually happens when someone sells something they don't legally own? It's a scenario that sparks literally countless legal battles, and today we're going to play judge and jury.
Welcome, first-year law students. In this official explainer prepared by Zuramazem Sainen UiTM Kawangan Johor, we're going to take those dry, dusty property statutes and turn them into an active courtroom drama. We want you to truly master the mechanics of ownership and have a little fun doing it.
On today's docket, we'll examine a stolen car dispute, decode a famous Latin maxim, hear some rapid-fire witness testimonies on major legal exceptions, and finally, deliver a verdict. Let's get to it.
We'll open the case file with Section 1, the stolen car dispute, exploring a classic conflict of ownership.
To really set the scene here, I want you to picture a super common, everyday scenario. Let's say you borrow a lawnmower from your neighbor. It's sitting right there in your garage, you're holding it, but you don't actually own it, right? Well, what if you turn around and sell it to someone down the street who has absolutely no idea you just borrowed it? The big question for the court is, does that innocent buyer actually own it now?
Let's raise the stakes a bit with Exhibit A. We're not just talking about lawnmowers anymore. What if a seller offers you a gorgeous red car? You pay for it, you get the keys, you drive it home feeling great, but then you find out it was actually stolen from someone else. Do you get full, good title to it just because you paid for it in good faith? Or can the true original owner legally demand it back?
To answer that, we've got to look at Section 2, the Nemo dat rule, which is literally the foundation of property transfer.
This brings us to a very dramatic Latin maxim, Nemo dat quod non habet. I know, it sounds a bit intimidating, maybe like a spell from Harry Potter, but it's actually a highly logical concept designed to protect property rights.
It translates beautifully into simple English as, no one can give what he does not have. Think about it for a second. If you don't own something, you can't magically pass ownership of it to someone else. Meaning, if the seller isn't the true owner, the buyer gets absolutely no title. This essential bedrock rule is officially codified in Section 27 of the Sale of Goods Act 1957.
Let's map this out clearly so we can track the chain of events. First, you have the true owner. They hold the actual legal title. Second, you have the seller. They might have physical possession of the item, like our lawnmower or the red car, but they have zero title. Because of that, step 3 means our innocent buyer gets absolutely no title, even if they paid full price in complete good faith. Under the general rule, the true owner wins and they can claim their property right back.
But wait! The law isn't always so rigid. Honestly, if it was, commerce would totally grind to a halt. So let's move to Section 3, witness testimonies on the exceptions, and see exactly when the innocent buyer actually wins.
Witness number 1 tells us about estoppel, also found in Section 27. Imagine the true owner is just standing right there while someone else sells their stuff to you. The owner nods along, acts like it's perfectly fine. If the true owner induces you, literally tricks you into believing the seller has the authority to sell, the owner is estopped or legally blocked from claiming their rights back later. You bought it in good faith, for value, so you get the good title.
Next on the stand is the mercantile agent. This is the proviso to Section 27. Think of an auctioneer, a broker, or a car dealer selling goods for a commission. They aren't the true owners of the item sitting on their lots, but they are commercial agents. If a mercantile agent sells you goods as part of their regular, everyday business, and you buy in good faith, you get a solid, good title over those goods.
Our third witness introduces a scenario involving joint owners under Section 28. Sometimes goods are owned jointly by several people. If one of those co-owners has sole possession of the item, with the express permission of the others, of course, and they sell it to a buyer who's acting in good faith, that buyer gets the title.
To picture this, let's take a look at Exhibit D. Say this household iron is jointly co-owned by 3 roommates, Anita, Patricia, and Cassie. If Anita has sole possession of it with their permission and she suddenly decides to sell it to you, well, you miraculously get full good title. The other roommates can't come after you to get their iron back. They're going to have to take that up with Anita.
Witness 4 introduces Section 29, Sale under Avoidable Contract. This happens when the seller originally got possession of the goods through a severely flawed contract. Maybe they used coercion or deceit, but crucially, the original victim hasn't officially canceled or rescinded that contract yet. Exhibit C brings this right to life. Let's say a bad actor uses coercion to force someone to hand over a silver laptop. That makes the contract voidable. But before the original owner officially rescinds it, the bad actor quickly turns around and sells it to you. Because you are an innocent buyer acting in good faith, totally unaware of the sketchy coercion, the law says the title legally belongs to you.
So, as you can see, timing really matters. Witness 5 covers Section 30, subsection 1. Imagine you buy something at a shop. The ownership officially passes to you, but you leave it at the store to pick up later. You are the first buyer. Now, imagine that sneaky seller turns around and sells the exact same item to a second buyer.
Let's use the lovely floral vases in Exhibit D as an example. If you are that second buyer and you bought them in good faith, totally unaware they were already sold to someone else, the law actually protects you. Under this exception, the second buyer gets the good title over the original first buyer. The first buyer would have to sue the seller for damages, but they don't get to keep the vases.
Our final witness details the flip side of that. Section 30, subsection 2. Here, a first buyer takes the goods home with the seller's consent, but officially, the legal title hasn't passed to them yet. Maybe they're paying in monthly installments. Even though they don't have the title, they turn around and sell the goods to a second buyer anyway. Brilliantly, if that second buyer buys in good faith and for value, they win. The first buyer can actually pass a good title to the second innocent buyer.
Okay, future lawyers, you might want to screenshot this summary. Here is your complete case recap of all 6 exceptions to the Nemo DAT rule, complete with their Exact Sale of Goods Act 1957 citations. We've got estoppel, mercantile agents, joint owners, voidable contracts, the seller in possession, and the buyer in possession. In all these specific scenarios, the innocent buyer triumphs over the general rule.
The testimonies have concluded, the evidence is all laid out, so it's time for us to hand down our ruling. Section 4, the final verdict, where we balance rights in commercial law.
Our final verdict reveals a really fascinating truth about commercial law. It's all one massive, delicate balancing act. On one hand, the general Nemo DAT rule strictly protects original property owners from theft and unauthorized sales. But on the other hand, the 6 exceptions we just reviewed are absolutely crucial for safeguarding innocent buyers who are just trying to engage in everyday transactions in good faith. Without these exceptions, the marketplace would literally be paralyzed by mistrust.
So, having seen all the evidence in today's session, I'll leave you with this provocative thought. Based on these 6 massive exceptions we just learned, does the law actually protect the true original owner, or is the entire legal system quietly designed to favor the innocent buyer just to keep the wheels of commerce turning? Think about that next time you buy something secondhand. Thanks for joining me in this explainer, and court is officially adjourned.